Moments like these are rare in American law. Every so often, a decision emerges that quietly but decisively reshapes how the Constitution is understood across the country. This was one of those moments. Without fanfare, without dissent, and without ideological division, the Supreme Court issued a ruling that resolved a long-standing constitutional conflict, one that had quietly altered the meaning of fundamental rights, depending on where someone lived. The significance of this decision does not rest on dramatic courtroom scenes or political clashes, but on something far more consequential: the promise that constitutional protections should not change from state to state. At the heart of this ruling was a deep and unresolved disagreement among federal courts. For years, judges across the country had been interpreting the same constitutional provision in starkly different ways. In some regions, courts applied a broad, context-based analysis when evaluating whether government force was reasonable. In others, particularly within the Fifth Circuit, judges relied on a far narrower framework. These differences were not technical details or minor legal nuances. They affected the very substance of constitutional rights, guaranteed under the Fourth Amendment. The practical result of this divide was troubling. A person's legal protections could depend almost entirely on geography. Someone in California or New York might receive one level of constitutional scrutiny, while someone in Texas or Louisiana faced another. The Constitution, which promises equal protection, had effectively fractured into regional interpretations. Justice, in these cases, was anything but uniform. Data collected from appellate courts revealed just how severe the problem had become. Between 2018 and 2023, federal courts of appeal issued more than 240 published opinions addressing this specific constitutional question. In roughly 60% of those cases, courts disagreed on the correct legal framework to apply. This meant that attorneys, plaintiffs, and even government lawyers were navigating a legal landscape where outcomes were unpredictable. Success or failure often depended less on facts and more on jurisdiction. Even the federal government adapted its arguments depending on where a case was heard. Knowing that different circuits applied different rules, government attorneys adjusted their positions accordingly. This inconsistency highlighted how deeply entrenched the problem had become. The law itself was no longer speaking with a single voice. The case that ultimately reached the Supreme Court did not initially appear extraordinary. It arose from an everyday encounter between a private individual and law enforcement, an interaction that, at first, showed no signs of imminent danger or criminal escalation. The situation unfolded quickly, lasting less than half a minute from start to finish. Yet within those brief seconds, a sequence of decisions led to the use of force with permanent consequences. Following the incident, the individual's family filed a federal civil rights lawsuit alleging that the force used was excessive and unconstitutional. They argued that the Officer O.S. earlier decisions had unnecessarily escalated the encounter and that those choices should matter when assessing reasonableness. But when the case reached lower courts, the analysis stopped almost before it began. The court relied on what had come to be known as the moment of threat rule. Under this approach, judges focused exclusively on the instant force was used, ignoring everything that happened beforehand. Tactical decisions, missed opportunities to de-escalate, and the officer's own role in creating risk were deemed legally irrelevant. Only the final moment mattered. This framework produced outcomes that alarmed legal scholars and civil rights advocates alike. In multiple cases, courts upheld uses of force even when officers had made dangerous or unnecessary choices leading up to the confrontation. As long as a perceived threat existed at the final second, earlier conduct was effectively erased from the legal analysis. Critics argued that this approach rewarded poor judgment and undermined professional police training. Academic research reinforced these concerns. Legal scholars demonstrated that the moment of threat rule conflicted with both constitutional principles and real-world policing standards. Law enforcement training emphasizes assessing situations holistically, anticipating risks, and using de-escalation whenever possible. A legal rule that ignored these elements, critics argued, distorted both the law and police accountability. The central constitutional question was simple but profound. If an individual A.S. own unreasonable decisions create a dangerous situation, can those decisions be ignored when evaluating responsibility? In the Fifth Circuit, the answer had often been yes. Elsewhere, courts disagreed. Reaching the Supreme Court is notoriously difficult. Each year, the court receives thousands of petitions and agrees to hear only a small fraction. This case stood out because it presented a clear and undeniable circuit split. Multiple federal appellate courts were applying fundamentally different legal tests to the same constitutional issue. Such divisions strike at the court's core responsibility to ensure uniform interpretation of federal law. The petition laid out the conflict in stark terms. While the Fifth Circuit adhered to the moment of threat rule, nearly every other circuit applied a totality of the circumstances approach. These courts evaluated the full sequence of events, recognizing that reasonableness cannot be assessed in isolation. The inconsistency was undeniable, and the Supreme Court took notice. When the court agreed to hear the case, interest surged. Both sides submitted extensive briefs, and numerous organizations filed amicus briefs highlighting the broader implications. Still, few anticipated the outcome that followed. The Supreme Court's decision was unanimous. All 9 justices agreed not only on the result, but on the reasoning. In an era marked by sharp ideological divides, such consensus carried extraordinary weight. The opinion, authored by Justice Sonia Sotomayor, methodically dismantled the moment of threat rule. The court began with the text and history of the Fourth Amendment. The framers, the opinion explained, understood reasonableness as inherently contextual. A determination of whether government conduct is reasonable requires examining all relevant circumstances, not just a single isolated moment. Historical sources, early legal practices, and long-standing precedent all supported this view. The court then turned to its own prior decisions. For decades, Supreme Court jurisprudence has emphasized that constitutional reasonableness depends on the totality of circumstances. Landmark cases made clear that context matters, and that legal analysis cannot ignore the events leading up to a challenged action. The Fifth Circuit's approach, the court concluded, was incompatible with this established framework. Beyond doctrine, the opinion addressed practical realities. Policing, the court observed, involves continuous decision-making. Officers are trained to assess evolving situations, manage risk, and avoid unnecessary escalation. A legal rule that disregards these factors not only misapplies constitutional law, but also fails to align with professional standards. The consequences of the ruling are far-reaching. Hundreds of cases currently pending in federal courts involve similar claims. Those cases must now be reconsidered under the correct legal standard. In the Fifth Circuit alone, dozens of active cases are directly affected. Plaintiffs who previously faced dismissal may now have their claims reevaluated with a full examination of the facts. Law enforcement agencies are also taking notice. Use of force policies and training programs must now reflect the court's guidance. Officers will be judged not only on split-second decisions, but also on the choices they make leading up to those moments. Accountability, under this framework, extends across the entire encounter. Perhaps most striking is what did not happen. There were no concurring opinions offering alternative reasoning. There were no dissents challenging the outcome. Justices appointed by presidents from both major political parties, representing diverse judicial philosophies, spoke with one voice. The message was unmistakable. The Constitution demands a comprehensive evaluation of government action. While the case arose from an excessive force claim, its implications extend further. Any Fourth Amendment analysis involving searches, seizures, stops, or arrests must now adhere to this totality-based approach. Courts can no longer isolate government conduct from the context in which it occurs. The decision also reinforces a broader principle of constitutional interpretation. Text, history, and practical reality are not competing considerations. They work together. When applied faithfully, they produce rules that are both principled and workable. Looking ahead, the true impact of this ruling will unfold over time. Lower courts must apply the standard consistently. Law enforcement agencies must adapt their practices. And individuals must understand what this decision means for their rights. At its core, the ruling reaffirms a simple but powerful idea. Constitutional protections are not confined to a single moment frozen in time. They exist within the full story of how events unfold. When courts evaluate government power, they must see the whole picture. Only then can the promise of equal justice under the Constitution come closer to reality.